All right, we have a full room right now. So in the interest of time, I'm going to get started. Welcome everyone. My name is Jean-Paul Bevilacqua. I'm a program developer here at OJEN, and welcome to our 2022 Summer Law Institute webinar series. I so appreciate you all being here today for this really interesting, but also hopefully directly applicable conversation on R.V. Sullivan, Chan, and Brown, which was trio cases that back in May, the Supreme Court of Canada released their decision on. And then based on that, the federal government put in amendments to the Criminal Code of Canada in the following month of June. Before we get started though, to the cases themselves, I would just like to acknowledge that I'm talking here from Toronto, and I know we have people from across the province, but me personally, I would like to acknowledge that I'm here on the traditional territories of the Mississauga and Credit First Nation, the Anishinaabe, Haudenosaunee, Wendat, and Huron peoples who were the original stewards of this land, and I'm grateful to be speaking to you all today from Toronto. And just connected to that, when we're talking about criminal justice, as we will be today in this webinar, I also just like to have the lens of thinking about the overrepresentation of Indigenous peoples, both as victims and survivors of crimes, as well as accused and convicted individuals, and not just to state that fact, but to realize the kind of roots and causes of that, including, colonial history of Canada, systemic discrimination, socioeconomic status, and other factors. And although that's not the intentional focus of today's webinar, I think it's worth having that lens when having these types of discussions. I'd like to now welcome our two esteemed speakers that, let me just back up a little bit. When we were formatting today's program and this week's program, this case and profiling it was something that was a priority for OJEN. And for me personally, when the Supreme Court rendered its decision back in the spring, I saw a lot of discussion and posts on social media, both from my generation and the generation below, so millennials and Gen Zs, with very strong ideas about what this decision meant, and a healthy amount of fear. So I think some of that was, of course, well-founded and worth considering. And then I also saw a little bit of perhaps misinformation being spread around about the exact consequences of this decision. And of course, it was also allowed to spread because legislation hadn't been, and the amendments hadn't been drafted by the federal government's, based on the decision. So I think it's great that we're all here today to explore exactly what these decisions mean, and also what the legislation and the amendments entail. So to that extent, we have Stephanie DiGiuseppe, who is a precedent-setting advocate and lawyer with Ruby Shiller Enenajor DiGiuseppe Barristers, who has been counsel on some of Canada's most complex and high-profile cases, R.V. Sullivan being one of them. She has over a decade of litigation experience, and is a really notable and skilled advocate in our country. And secondly, we have Pam Hrick, who is the Executive Director and General Counsel at LEAF. She leads and manages LEAF's legal activities and daily operations, and also works with the board. She provides leadership, expertise, support, and direction to LEAF's work on litigation, law reform, and public education. So I should also mention too that LEAF was an intervener on one of the cases at question here. So we'll get two differing perspectives on both the cases themselves and what they mean. And that was really important for us here today to hear from a couple different perspectives. So thank you, Stephanie and Pam, for being here today. And with that, I will pass it over to Stephanie. And I should mention too, if you have questions or comments throughout, please use the chat and Q&A functions, and I'll be making sure to pay attention and field those questions for you all. Stephanie.
Thank you so much. Hi, everyone. I'm so happy to be here speaking to you today about this case. Thank you for your interest in this case. It's a very important case, and it's a very important case to get right, as Jean-Paul mentioned, especially when we're dealing with educating young people about what this case does and doesn't mean. I think I'll start off by just acknowledging that this is a very controversial case. It's a complicated case, one of the most complicated of my career in terms of wrestling philosophically with the different issues and interests that were at play in the case. And no doubt it will be a difficult case to teach to young people. There is a lot of emotion around it. We saw that on social media. We saw it in the media after the decision was released. Now, there's a lot of controversy about this case that is just legitimate, interesting controversy, but there is also a large percentage of emotion and controversy that I believe, and I think that you'll hear this from Leif as well, comes out of misinformation about the case. And so we hope today to help you with the proper interpretation of the case, to help you understand the context of the case and its ramifications, so that we can make sure that young people who are learning about this case have the right conversation about what it means and about the controversial interests at play. So I'll start by just giving you one sentence on each of the cases that has to do with the facts of the case. Where did these cases come from? There are two Ontario cases. The first one I was counsel on, that's the case of David Sullivan. And David Sullivan is a particularly vulnerable person. And at one point he tried to commit suicide by taking a massive overdose of his prescription anti-anxiety medication. He went into a state of toxic psychosis, which I'll talk about a little bit today, what that means. And he stabbed his mother. And so that's the first factual circumstance that gives rise to bringing this constitutional issue to the Supreme Court. The second case, also from Ontario, is the case of Thomas Chan. Thomas Chan was a young man in his late teens, I believe. He took magic mushrooms, psilocybin, and because of pre-existing traumatic brain injury he had from a number of concussions, he had a very rare reaction to psilocybin. While he was in that toxic psychosis again, he killed his father and seriously injured his stepmother. And then the final case coming out of Alberta is Brown. Brown is also a psilocybin case. And Mr. Brown took psilocybin, again, went into toxic psychosis, and he assaulted his neighbor, And so all of these cases kind of bring together one common theme, and that's the question of whether a person who commits a criminal offense while in a state of self-induced extreme intoxication should be found guilty for the criminal offense they commit. And there's two really important concepts there. So the first is extreme intoxication. Extreme intoxication doesn't just mean very, very intoxicated. It is a legal term of art that refers to a very particular mental state that is both rare and complex. So it doesn't mean that you're blackout. Not having a memory of events is not the same as it being extremely intoxicated. And it's very rare. So at the Supreme Court, I kind of explained it this way. I said, if you can imagine intoxication like a train, and you get on the train, and as you continue to take more intoxicants, it fuels the train towards your ultimate destination of what colloquially we might call very, very intoxicated or extremely intoxicated. The legal extreme intoxication we're concerned with in these cases isn't the train getting to its destination, it's the train derailing completely and going into this very complicated psychiatric state where the person loses volitional control over their actions. So not just that their inhibitions are lowered, that's normal intoxication. This is almost being in a sleepwalking-like state, or toxic psychosis, which is being in a state where you are not just hallucinating, not just simple hallucinations, but you've gone completely into a state of psychosis like someone with schizophrenia might experience in the most acute form of that disease. The other really important concept is self-induced. Self-induced has a very clear definition in law as well. And it means that you don't have to, it doesn't mean that you meant to get very, very intoxicated. It just means that you took an intoxicant willingly. So one of the problems with this idea that we talked about in these cases was that if you took a substance like Sullivan and Chan and Brown did, not intending to become incredibly intoxicated, but you became extremely intoxicated because of a rare reaction, like a unknown medical susceptibility to side effects of a drug. Then you would be caught within this provision and you wouldn't have a defense for your conduct. And I'll use an example that came up at the Court of Appeal in Ontario when we argued this case, was the example of somebody who takes their psychiatric medication that's prescribed to them by a doctor, and they take it the way that it's prescribed by a doctor. But because a rare known side effect of that medication is psychosis, if they go into that psychotic state, they would be captured under this law and they wouldn't have a defense for anything that they did while they were in that state, even though they didn't mean to go into it. Okay, I'm going to take a moment now and just tell you a bit about the history of where these cases are coming from, because that's an area that's a little bit complicated and kind of important to understanding the context of the cases. Originally, we had a rule called the Leary Rule, and the Leary Rule said that intoxication is never a defense to criminal activity. And by and large, that's still true. So all those other kinds of intoxication, all the stops on the train going to its destination I spoke about earlier, none of that remains a defense. Being very, very drunk is still not a defense to crime in Canada. What happened with the Leary Rule is that in a case called Davio, which was a terrible case with terrible facts, the Supreme Court of Canada carved out an exception to that Leary Rule for these complex states of extreme intoxication. And they did that because of our charter. Our charter guarantees particular rights to individuals that are closely connected to the state's ability to convict someone of a criminal offense and take away their liberty as a result. And these are the bedrock of criminal constitutional law in Canada. So things like the presumption of innocence, which says that a person cannot be convicted unless the Crown proves its case beyond a reasonable doubt. And that comes out of Section 11D of the Charter. And then also Section 7 of the Charter, which protects individual liberty and says the state can't take it away unless they do it in accordance with the principles of fundamental justice. Our courts have defined the principles of fundamental justice as protecting things like the requirement that the person has mens rea, the guilty mind, the requirement that a person acted voluntarily, they made a conscious volitional choice to do what they did, and several other ideas that really are related to those, but have to do with when the state can substitute proof of one fact for proof of those essential elements of mens rea, guilty mind, and voluntariness. And I think it's useful here to think about what our criminal justice system does. So our criminal justice system is not designed to address all harm that happens to innocent victims. So if I get in a car accident, but I'm driving I'm driving properly, or I'm driving a little bit badly, but not very, very badly. I may hurt someone, I may even kill someone, but our criminal law isn't designed to capture every act a person may commit that causes harm to another person. It doesn't capture simple negligence. The criminal law is really focused on capturing people that act with a guilty mind and a conscious choice to do bad to others. And
Stephanie, can I just, sorry to interrupt.
Yeah, absolutely, interrupt me.
So can you distinguish between what you just said with the knowledge of many individuals having been convicted and incarcerated for smaller crimes? So, you know, someone shoplifting something of not a lot of value, how does that square with what you just said about the criminal law not being designed to capture all harm?
Sure. I think, you know, people who agree that people should be criminalized for shoplifting would say that, you know, because I think sometimes our net is cast too broadly in a lot of ways, but the choice, you still make a choice to shoplift. Even though the harm caused is small, there is a decision made to deprive somebody else who has legal ownership over something of that thing and to take it for yourself. And so you have that guilty mind, you have that intention to commit crime, and you have that voluntariness. You made a conscious decision to do it. Voluntariness is very confusing. A really good example of voluntariness that people use in law class, for example, is if, you know, you kind of hit someone in their knee to trigger their knee reflex and their leg shoots up and they kick somebody else. That's an involuntary act. I didn't choose to lift my knee. My knee lifted itself. Voluntariness is a very low threshold. So when a person chooses to shoplift, they're not sleepwalking. They're not acting involuntarily and that their body did it, but their mind didn't control it. And they are intending to steal. So that's how. Your question about, you know, is the level of the harm enough that we should be using the criminal power for it is a good question. But that's how those two things would be reconciled the way the law stands now.
Thank you.
No, my pleasure. When Davio was decided, there was sort of a knee-jerk reaction, I would call it, from Parliament, because Davio is a horrible case where a man drank a lot of alcohol and then sexually assaulted a disabled woman. And there was a lot of controversy because people, and this is still the case, the forensic psychiatric community in Canada still don't really think that alcohol gets you there for this defense standing alone, that you can get so drunk that you go into this mental state. But Parliament reacted and they passed section 33.1 of the criminal code, and section 33.1 does what I talked to you about earlier. It says that even where a person doesn't have mens rea and they don't act voluntarily, if the reason they're lacking those things is because they did this self-induced intoxication, so they chose to consume an intoxicant. So, you know, if someone spiked their drink and they didn't know, that wouldn't capture them. Because a person in those situations, it's not a defense that you lack the mens rea and voluntariness. And that's a really broad provision. And so I'm going to turn it over to Pam in a second, but maybe I'll just tell you how that got us to David Sullivan, because I think it's interesting to think about. David Sullivan, when I met him, he's a very vulnerable person, experienced homelessness, terrible child abuse, was the victim of an aggravated sexual assault in his early 20s. And all of those things came together and affected his mental health. And at one point he decided to try to kill himself. And when he retained me to do his appeal, at that point he was in jail. He was in solitary confinement because he was a target of other people in jail. They would hurt him. And so the only way to protect him was to put him in solitary confinement. His health was terrible. He could barely stand up. He was using a walker. He had lost 50 pounds in jail. And all of that was awful. But the worst thing to him, like worse than all of that, was the idea that he had been convicted of stabbing his mother when he didn't choose to do so. And so I felt very strongly upon meeting David that a person in his shoes who tries to commit suicide and has a freak reaction shouldn't be held responsible for what they did when they had no guilty mind and no intention to do it. And the answer was that 33.1 was a bad piece of law. It may catch some bad guys, but it also caught some not bad guys, even though their bodies had done bad things. And so it needed to be fixed. There was a lot of tension, though, between the interests of victims of violence and the interests of accused people like David Sullivan. And so a lot of the controversy in the case and controversy under the Section 1 test, the Oakes test, had to do with whether we should be incarcerating people who were legally innocent, people who didn't have mens rea, didn't act voluntarily, in order to deter future acts of sexual violence. And I thought the answer to that, or future acts of violence or sexual violence, and I thought the answer to that question had to obviously be no. We need to deter violence and sexual violence. We need to deter intoxicated violence in our society, but we shouldn't be doing it by convicting innocent people. That's not the right way. There are other ways to do it. And so I think, that's a real area where everybody here as educators can come in. One of the dangers that the Crown and Leaf spoke about at the Supreme Court was, will this deter the reporting of sexual crimes? And it might if the case is misunderstood, and it shouldn't if the case is properly understood. So some of the things that we can think about when we're thinking about those questions and talking to young people are actually what this defense means. I spoke about the fact that it doesn't just mean you're really intoxicated. It means you're in this complex mental state, and it is very difficult to prove. In Sullivan and Chan's cases, both of them, there were accounts of the victims, accounts of eyewitnesses, accounts of police officers and medical professionals who saw Sullivan and Chan when they were in states of psychosis. Both of them had toxicology testing done while they were in states of psychosis that proved the level of drugs in their systems objectively. They were all assessed by psychiatric personnel while in that state of psychosis. Then they were all assessed again by other forensic psychiatrists after the fact in order to substantiate that. There's a requirement in this case that an expert agree. In all cases of this defense, there's a requirement that you call a doctor, a forensic psychiatrist who agrees that you were in a state of toxic psychosis or automatism at the time. My client, David Sullivan, was assessed for 60 days. He was kept at Ontario Shores, which is a forensic hospital in Ontario, for 60 days under observation before a doctor rendered an opinion that this was caused by toxic psychosis, by this drug use. And it's a very hard case. It's a very hard thing to prove. It will be very difficult for if a accused person, for example, simply goes and meets with a forensic psychiatrist and says, well, I don't remember what happened. The forensic psychiatrist is going to say, maybe you were in that state and maybe you weren't. I can't know. It requires quite a heavy load of evidence that substantiates the idea that this person was actually psychotic or an automaton at the time, as opposed to just being very, very drunk. And so people should not be afraid to report sexual violence as a result of this case, just because the accused or the victim or both were using drugs and alcohol at the time. I think I've taken up a lot of time, so even though there's a lot to talk about in this case, I'll leave it to questions, and I'll turn it over to Pam to talk a little bit more about how we can help educate young people about the issues that this case raises.
Thanks very much, Stephanie. I wanted to first take a step back and let folks know about LEAF and what we do. And LEAF is the acronym that we use for the Women's Legal Education and Action Fund. We're a non-profit national organization that's dedicated to advancing the equality rights of women, girls, trans, and non-binary people. We were founded in 1985, which is the very same day that Section 15 of the Charter, which is the equality rights provision, came into effect. For 37 years now, we've been advancing gender equality through litigation, law reform, and public legal education. For much of our history, our litigation work has really been our bread and butter work. We intervene in cases frequently before the Supreme Court of Canada. Intervening means that we appear and make submissions to a court in cases that they're hearing, where we bring a useful and different perspective that'll be helpful to the court in deciding the case. So we've intervened in over 160 cases over our 37-year history, including 60 before the Supreme Court of Canada. We've been involved in cases on all sorts of issues relating to gender equality, including sexual assault law, family law, pension law. I'd say that practically every Supreme Court case that has engaged women's rights over the last 37 years has LEAF's fingerprints on it. And we've been, I'm proud to say, vital in shaping, I think, the charter rights that currently exist in Canada, especially in relation to Section 15 equality rights. We also do, as I mentioned, law reform and public legal education. One thing that I think is probably of particular interest to this audience today is that we're in the final stages of developing a program that is targeted for high school students and university age students on consent in the digital age, which we're going to be rolling out in the months to come. And we do that through our volunteer branches mostly. So as Executive Director and General Counsel of LEAF, I lead a team of 9 full-time staff members at our national office here in Toronto. And we also have 11 volunteer-driven member branches across the country, including branches in Thunder Bay, Windsor, Sudbury, Hamilton, Toronto, Kingston, and Ottawa. And I'm at the end of this going to drop some resources in the chat so that folks have a link to see what our branches are all about and consider joining if you'd be interested. So Stephanie, I think, gave a really great overview of both the history of Section 33.1 of the Criminal Code, of Davio, and the circumstances that really led to an outcry on behalf of the public and the introduction of Section 33.1 almost 30 years ago now. So it took almost 30 years for the Supreme Court to make a decision or to have a case presented to it that dealt with the challenge to the constitutionality of Section 33.1. And that's even though over the years there had been a number of challenges in the lower courts raising the very issue that was dealt with in this case. So we intervened in the cases of Sullivan and Chan at the Ontario Court of Appeal. And then we intervened in that case as well at the Supreme Court, as well as Brown, which is the decision in which you'll find all of the analysis about the unconstitutionality of Section 33.1, as Stephanie said. It was important for us to intervene in this case as LEAF because of the context in which Section 33.1 was introduced. Intoxication and violence against women and gender-based violence often go hand in hand. And Parliament with Section 33.1 was trying to recognize that women and children who are disproportionately the victims of violence, specifically domestic violence and sexual violence, deserve to have their dignity and equality rights upheld. So we at the Supreme Court wanted to focus on ensuring that that purpose of Section 33.1 and the rights of women and children to live lives free of violence were given due consideration when the court decided whether or not Section 33.1 was constitutional. So what does the Supreme Court's decision mean? I think that Stephanie also covered this pretty well. I'll try to supplement it a little bit. In the decision in Brown, obviously it struck down Section 33.1 as a violation of accused persons' charter rights. It meant in practice that people could no longer be prohibited from raising the defense of self-induced extreme intoxication akin to automatism for crimes including sexual assault. So that meant in practice, to reiterate what Stephanie said, that you could successfully use the defense if you had expert evidence that you presented to the court that you were in a state of automatism at the time of the alleged offense, and that the court accepted on a balance of probabilities, i.e. that it's more likely than not that they were in that state of automatism at the time that the underlying offense, the criminal offense, was committed. So it's important to note in that context as well, just to understand how this works in practice, that the Crown can also challenge the evidence the defendant calls, and it can call its own evidence as well. So the sort of practical impact of the decision in a nutshell, I'd say, is that there's no doubt there will be a handful of cases, I think, where someone will be able to access the defense and avoid being found guilty of the underlying alleged criminal offense. Those cases, though, are going to be rare. And the people raising this defense, I think it's fair to say, have an uphill battle in order to prove it. The case remains, as Stephanie said, that being simply drunk, very drunk, or even blackout drunk is not a defense to sexual assault and other crimes of that sort of nature. So once that decision came down from the Supreme Court, the government had a choice that it was had to consider whether or not to enact legislation to address what it saw as a gap in the law that was created after the Supreme Court's decision in Brown. In that decision, the court gave Parliament a couple of examples of options that could get at the harm they purported to want to address. So in a nutshell, accountability for intoxicated violence that were less impairing of accused person's charter rights. And that is actually part of the reason why the court said Section 33.1 was unconstitutional. The government decided to enact one of those options through something called Bill C-28 back in June. It is basically a narrower version of Section 33.1. And it says that someone can still be convicted of a crime, what they call a crime of general intent, which is a category of offenses in criminal law that includes sexual assault. They can be convicted of a crime where they are in a state of self-induced extreme intoxication if the Crown can prove beyond a reasonable doubt that there was a foreseeable risk that they could violently lose control over their actions when they consumed the intoxicants, and they failed to take enough care to prevent that risk. It's a very, very narrow, I call it a sort of narrow exception to that ability to raise the defense of self-induced extreme intoxication akin to automatism.
And that became, sorry to
certainly.
interrupt. I personally found that wording very interesting when it came out, because it's worded in a not of a broadening of defenses, but in actually kind of like a negative way, right? In terms of like, this is not allowed. And so can you explain why that was important for you to see in the wording of the legislation, that it wasn't kind of like a, here's what's now allowed, it's actually a very specifically worded way of interpreting the court's decision?
Yeah, it's a very narrow, tailored, in my view, response that aligns with exactly what the Supreme Court was saying could be a less impairing alternative. And it aligns with a concept of criminal negligence in criminal law as well, which is well known to lawyers who practice in that area. And it really focuses on trying to avoid capturing the kind of people like Mr. Sullivan, who were very much morally blameless in consuming intoxicants. And it says we're going to put the burden on the Crown to prove, if they are in this circumstance, that they did this in a way that is very much a departure from norms of behavior that create risk and that fail to mitigate risk that they could cause violent harm to somebody else. So in my view, I think it places the burden where it should be, which is on the Crown to prohibit effectively, or to otherwise find somebody guilty for conduct of which they are morally blameworthy. Not that sure if that's any clearer in addressing what you were getting at. But
No, it is. I think, and I put it in the chat just so everyone can see what we're talking about, because I think, when we talk about court decision, that's one thing, but the court tasked the federal government here to make amendments. So it was really, there were multiple steps to this process for the ideas of the courts to become law. So I think, it's great to talk about the decision and the justification there, but it's also really interesting to look at the wording that was chosen in making the amendments to section 33.1. So thanks, Pam.
Yes, definitely. So I think one of the things to take away is that it's important to understand the context in which these decisions were made, specifically in which Brown was made at the Supreme Court, given that it has all of this analysis and sets these rules out and makes these findings about constitutionality of the former provision. But it's important to know that Bill C-28 enacted an amendment to the criminal code, which now governs. So that is the law of the land in Canada. It became law in June of 2022, and it is an amendment to the criminal code that we have supported at LEAF as something that is narrow, nuanced, and we think constitutional, in line with what the Supreme Court suggested would be a more minimally impairing alternative to the former section 33.1. So I wanted to just touch on what people should know now about what the law currently is. And sort of build on what I've just said. In the wake of the Brown decision, we at LEAF, like I think a lot of you, and like JP was saying at the outset as well, we heard a lot of concern, mostly from young women, trans and non-binary people, because we know that girls and women aged 15 to 24 in Canada are at a much higher risk of experiencing sexual violence. And we also hear so much about campus rape culture as well. So we understand the confusion and the outrage that we heard, and it only confirmed further for us that it's a really scary reality that hits far too close to home for so many of the young people that we know in our lives, and in your case specifically, for those in the audience and the students that are in your classrooms every day. So if I had to sort of sum up the state of the law right now, I'd say, number one, simply being drunk, very drunk, or blackout drunk is not, nor has it ever been, a defense to sexual assault. The number two is that it will be very rare for someone to successfully rely on the defense of self-induced extreme intoxication. And the third thing, I think, is that the law very often does not provide an adequate response to sexual violence, which leads me to talk a little bit about what Stephanie alluded to at the end of her presentation, which is what are the other sort of solutions out there? Because we know the criminal law doesn't work well for so many survivors of sexual violence. It re-traumatizes them. It can expose them to invasive cross-examination on intimate violations of their body, their autonomy, their dignity, and their equality. And that is not really a bug, but that's a feature of the criminal system. The criminal system is fundamentally, in my view, not built to deal with the overwhelming majority of cases of sexual violence. We also know that the criminal law disproportionately captures and is brought down on Black, Indigenous, and racialized people in quite discriminatory ways. And again, I'd say that's not necessarily a bug up, but a feature of the criminal system. And I think it's a reality we need to take into consideration when we're talking about these issues, as JP said at the outset. So at LEAF, what we're doing right now is we're launching an alternative justice mechanisms for sexual violence project, which is going to explore other ways of dealing with sexual violence in a survivor-centered way. And so that means looking at options like restorative justice, transformative justice, looking at post-secondary processes that offer additional options to survivors to choose from as they seek accountability and justice when they've been sexually assaulted. And that does so in a way that encourages everyone involved to acknowledge harms committed, and specifically the person who has committed those harms to acknowledge and take ownership of them, which is quite frankly, because of the nature of the criminal system, it's discouraged. And I understand why it is. So this is, I think, one of the reasons why it's important to look to other alternatives out there to safely and in an informed way offer options other than the criminal system for people who have been sexually assaulted. The other thing I wanted to highlight is the need for a fully funded national action plan on violence against women and gender-based violence that includes education and prevention as tools to combat sexual violence. I think education and I hope folks in the audience here would agree, education is just so key in ensuring that people understand the boundaries of consent, that they engage with one another in a respectful way, and that we ultimately work towards preventing sexual violence, gender-based violence altogether. So that's one of the reasons I'm really excited about the program that we're going to be rolling out in the coming months, which is called Double Tap on Consent, our consent education in the 21st century program in the coming months. So I'll end there, and I will drop in the chat just a few resources on both the Brown decision and the National Action Plan, and a couple of other things that I hope folks might find interesting as resources.
Thank you so much, Pam. Connected to that, and I'm going to ask a question here, but I would like to open the floor too. So please use the chat or Q&A functions, and I'll make sure that your questions get asked and answered. Kind of a bigger one here from me, and I'm eager to hear from either or both of you on this. You know, we talk about precedent, which is like previous court decisions, and also statutory interpretation. So, right, in this case, it would be, you know, this new amendment to the criminal code. And I'm asking for a bit of a kind of a prediction here. Given that these cases were not involving facts of sexual violence, do you see it being even a higher threshold to cross into for this defense to be accepted in cases involving sexual violence? Do you think it will be applied equally? And then in connected, I'm just thinking about that the people at the center of these cases were all male identified. How does that factor in, if at all? So it's kind of two-pronged question, wondering for thoughts from either of you.
Sure. I'll start with the last part of your question. These three cases, everyone was male identified. We did a review of the case law in this area as part of our preparation for the Supreme Court case. And there were a small number, about a quarter of the accused people who tried to raise one of these voluntariness offense were women or female identified people. So it's not a defense that only men ever use. On the point about sexual violence, the legal standard will remain the same no matter what the charge is. So it will always be that it must be proven with a requirement for expert evidence on a balance of probabilities. Where I think it becomes really tricky as a practitioner to defend a sexual assault case this way is actually in mounting the evidence to convince a judge or jury that a sexual offense was committed in a state of psychosis or a state of automatism. The reason for that is because automatic violence, so violence committed in a state of automatism, which is best thought of as a state that's like sleepwalking when you're awake, is one of the big criteria for it is that it's not like directional. It's usually not aimed at someone you have a motive to harm, right? And it's usually not for a purpose like sexual gratification. Psychotic violence, if we look, for example, at the not criminally responsible regime, which is psychosis triggered by a mental disorder as opposed to taking drugs, we see sexual violence, people bringing NCR defenses to sexual violence, but this is a very small category. Most violence committed in a psychotic state is assault-based violence as opposed to sexual violence, just because those psychiatric states just lend themselves more to that kind of activity where they're violent at all. And I really want to stress this because not only are the states rare, but then being violent when you're in that state, it's not, I want to make sure it's clear to everyone listening that it's not by default that if you go into a psychotic and automatic state, you're going to be violent. Most people are not violent in those states. It's a very rare percentage of people who go into those states that then are also violent. And most of that violence is assaultive. So where the difficulty is going to lie with sexual violence is going to be convincing your expert that you actually committed that act of sexual violence when you were, because of psychosis and not just because your inhibitions were lowered because you had consumed intoxicants. So I think it will be much more difficult to prove for sexual assault cases, but that's a practical matter, not a legal matter.
And Stephanie, just connect to that, and Pam, of course, I want to hear from you. You use the acronym NCR, which for our audience, not criminally responsible. Maybe briefly, can you explain the difference between this now available defense and an NCR?
Yes, sure, no problem. So the NCR regime is a regime that says that people who commit an act when they are not criminally responsible because of a mental disorder, they are not convicted, but they are put into a the institutional mental health system. And so they are never convicted of their crime, but they may need to get treated before they are let out of the mental health system. It's very similar to what we're talking about, almost like a parallel system in a way. So the majority of mental illness, you commit a criminal offense and you happen to have a mental illness, that's not a defense. But if the mental illness that you have at the time of your offense meant that you could not understand the nature and quality of your actions, so you thought that you were you thought that you were cutting down a tree, but you were actually took an axe to a person, or you did not understand that what you did was wrong. So you thought that you were killing Satan, or you thought that God had told you to harm someone, but of course that was the product of delusion. If your mental illness creates one of those two states, then you're not held criminally responsible for your behavior, you're not convicted, but you are sent into a treatment regime.
Thank you, Stephanie. So yeah, less of a defense, more of a different pathway that the system uses to deal with those specific individuals and cases.
Absolutely, though I think it is important that you're not convicted. You're not responsible in law for your actions.
Thanks, Stephanie. Pam.
Yeah, if I can just chime in, because I actually want to ask Stephanie to explain something, because this is something that is a question I've gotten along the way since these decisions were released. The misconception that you can, for example, as a defense lawyer, go out, offer a retainer to an expert, and that expert will say whatever you want them to say. I wonder if it might be interesting for this audience to understand what you have to do as a criminal defense lawyer to get an expert opinion and the obligations of an expert to the court.
Yeah, that's a great question. So Canada has a very small expert community and it's very conservative. It is not like what you might hear about in the United States, where there's this idea that you can have a hired gun. Particularly the forensic psychiatric community, which is the professionals that would deal with these kinds of questions. These are, highly ethical, very, very highly skilled, trained individuals that care a lot about their reputation with the courts and their professional reputation. And there's really not a lot of them in Canada. It's not a huge market. And so when you go out to find one of these doctors, you're really facing with this kind of defense an uphill battle. And then, of course, even if you could find some charlatan, which is hard to do in Canada, the idea that the court's going to take that person seriously is very, very, very small. And so when I discussed earlier the kind of evidence that a forensic psychiatrist would look at, they would look at the entire police file. They would see all of the observations of witnesses. They would see, you can't just show them only your defense evidence. They have to see everything. They would interview the client multiple times, or like in David Sullivan's case, he was an observation for 60 days, being observed and interviewed every day. And they would be looking very strongly for objective evidence. So not just the accused person's self-report that this is what I took or this is what I drank, but things like toxicology results, so blood tests taken after the fact. Most of these successful defenses, the people actually end up in hospital because it's so obvious to the victim and everyone around them that they need medical attention. And so there's often hospital records as well that the doctor would be looking at, as well as looking through the person's entire psychiatric history if they have one before coming up with an opinion.
Thank you. Something I'm trying to wrap my head around just thinking about is, and I hope I'm able to articulate it, even in cases where this defense is successful, I think there's this idea that all is forgiven, they got off scot-free, there's no kind of consequence for actions. And I think that is part of our conditioning as a society that sees courts as the only way to repair harm. So I'm wondering from either of you, how do you see this change in the criminal code as perhaps allowing for different ways of accounting for harm, restoring relationships outside of the formal court processes?
I can take a first crack at that. I'm sure Stephanie can tell you that going to the end of a criminal trial, no matter the outcome, even if you receive a not guilty verdict, sure, it doesn't feel like to the accused like they've gotten off scot-free. It's just a horrible experience for everyone involved. And I think sort of to pick up on what you're alluding to, JP, really stepping back and thinking about what we think about as accountability and justice, and not seeing it in this narrow, through this narrow lens of what does a criminal court find, is more aligned with, I think, what I'll keep calling a sort of survivor-centric way of looking at sexual violence specifically, and I'll sort of stick to that context. I think it's important for us to understand the harms that are done so often going through a criminal process, and sort of on the other side of things, not just a not guilty verdict being a difficult thing for everyone involved. Sometimes a guilty verdict isn't just a bad outcome for in the eyes of an accused person, but it also sometimes doesn't necessarily bring the sense of relief and justice and accountability that survivors hope that they will experience and they'll feel at the end of the day anyway. And on top of that, it doesn't align necessarily with what a lot of survivors want to see, because well, for many reasons that people don't want to engage in the criminal justice system, generally speaking. So if we can find ways of stepping back and looking at different options that we can offer to survivors to choose for them, what is the right path to healing, accountability, and a broader sense of justice, I think that's a good thing, rather than to sort of continually try to push a square peg into the round hole of the criminal justice system when it doesn't always fit. That's the sort of work that I'm really interested and curious to explore at LEAF.
And I think Sarah's asking a question that is connected to what you were just saying, Pam. And Sarah says, isn't it fair to say that alternative justice measures are not adequately funded and available in a pragmatic sense, they don't actually exist in any meaningful way?
Yes, absolutely. One thing I'd highlight is the results of there was an inquest recently, Renfrew County inquest, following the murder of 3 women by their former partner, and the jury released, I think, last month, its recommendations stemming from the inquest. And one of them was to explore, for intimate partner violence, inappropriate cases, restorative and transformative options, restorative and transformative justice options that are fully funded, properly funded, in this case by the provincial government. You're very right, Sarah. Like, it's got to be properly funded. It's got to have, I think, parameters around it and clear guidance around it. in order to be effective. Otherwise, it's not actually an option.
Yeah, I think one thing that I would add to what Pam said, which I agree with everything she said, is that often the people who commit these acts, the fact that it happened is punishment enough. Like Thomas Chan is just a normal kid. I say that not disparagingly to anyone in the criminal justice system. Normal is probably a bad choice of word, but he had no criminal antecedents. He loved his father, loved his stepmother very much. The fact that what happened, I think, was probably punishment enough for Thomas Chan. I would say the same for David Sullivan. Loved his mother very much. The harm that he caused his mother was tragic and a terrible thing for him to live with, and still is. And so that kind of, circles back to what I said earlier on in this presentation, that not all harm that happens needs a criminal justice solution. We cause harm to each other all the time, and sometimes just our humanity is enough to make that harm meaningful and cause us to switch our actions and not commit it again. I think for David Sullivan and Thomas Chan, that's certainly true.
Stephanie, as you're saying that, I think I am in agreement with you, but I think what a paradigm shift that is for society at large to think in that way, because I don't think that that's how we've been trained to think about notions of harm, punishment, and the pathways to getting that. I think that's a big, separate from this conversation or broader than this conversation, a real gear shift in terms of how we think about dealing with those who have committed crimes.
Mm-hmm. I mean, I always think about it the same way. I mean, everyone here is an educator. I'm a mom. Would you punish your child for something that they did unintentionally? What would be the point, except just to put more pain and suffering into the world? We punish our children for things that they do intentionally because it has a purpose to stop them from doing it again. I think about that case this way sometimes.
Yeah, thank you. All right. Oh, okay. I just want to make sure we get this last comment. Okay, Globe and Mail article. Yes, we will look into that, Rosalie. I want to make sure we're getting the right article circulated, and we'll have a feedback form and other resources circulated after this session, so we'll include that in that. Okay, so we only have a minute left, but let me try to get this last question addressed. So in the Chan and Brown cases with the ingestion of mushrooms, is there any criminal negligence on their part because they voluntarily took the drugs, even though they could not anticipate the outcome? They should have known something might happen, question mark. Pam, Stephanie, do you want to try to tackle that?
Maybe I'll just jump in because it requires you to understand criminal negligence. And so it's kind of a criminal lawyer question. So criminal negligence is different than simple negligence because you need to do a marked departure from what a normal person would do. And you need to do it with a wanton and reckless disregard for the life and safety of others. So the question really comes down to, is taking psilocybin something that is, something that is illegal but done by a whole bunch of people and almost never produces bad results like this, so that it may be simple negligence but not criminal negligence. Criminal negligence really means that you thought there was a good chance, if I could put it in layman's terms, you thought there was a good chance that someone else could be hurt by what you did and you chose to do it anyways. I think most people would think that taking magic mushrooms doesn't fall into that category, but it would really depend on the facts of each unique case. For example, if Thomas Chan had taken mushrooms before and gone into a state of psychosis, so he knew that that could happen to him, then that would probably be criminal negligence. This question raises so many interesting issues, but we're short on time, so I think I'll have to turn it back to JP and bite my tongue.
Yeah, I mean, I have follow-up thoughts and questions too, but you know, this conversation can live past and probably should live past this webinar. So I'm glad that we all still have things to think about it and grapple with. And I want to give a huge thank you to our panelists, Stephanie and Pam. I mean, I was so keen to get two differing perspectives on these cases, and again, the direct applicability to young people and ideas about behavior and what is now allowed. I was glad to see that that was fully addressed in this webinar. So thank you to you both. It was a pleasure to have you here. Couple of final things. We are in the middle of our Summer Law Institute week. We have a session this afternoon that is being run in tandem with Justice for Children and Youth on supporting youth without immigration status. The rest of the week is a kind of all-star lineup, if I may say so myself, of fantastic speakers and topics. So please join us for that. As I mentioned, there will be a feedback form and other resources circulated after this session, so please do check up on that. And then lastly, I want to thank the Law Foundation of Ontario for allowing us to run this program. Thank you, everyone. Have a great rest of your week. Pam and Stephanie, thanks again.
Thanks so much for having us.